agent for healthcare decisions. For conflict reasons and things like that. But in general, you can pick anyone that you want. You can have it as broad or as limited in scope as you want. These things can really be tailored. If you're using kind of a standard form, it can be a little bit more difficult to tailor them, but I think that's everything. Next slide. Okay. So the benefits of having a healthcare power of attorney done, particularly with people who have large families, it's good to have one decision maker, especially in emergencies, versus having kind of everyone having to make decisions by committee. Even with like a living will, you kind of, it prompts discussion about what you want ahead of time, and it encourages you to actually get that information out there to your family so that they know what you want, and they're able to better make decisions for you. Sometimes people don't want to do that, and all they want to do is just pick an agent who can make decisions, and that's fine as well, but at least then people around you know who you want to make decisions. And really it's all about, you know, preserving your autonomy, preserving you know, your values, what you want, particularly when you're not able anymore to communicate your choices. And so deciding ahead of time either who you trust to make those decisions, or you know, what decisions you would want made is really important. Next slide. So if you don't have a healthcare power of attorney, then it kind of generally, this is set by state statute who the medical providers will go to make decisions. So this is just an example for what the statute says in Maine. I know we have people from other states here, and I'm only licensed to practice in Maine, so I don't know what it is other places. But as you can see, the statute goes right down a list. So, you know, if you don't have any close family, you don't have a spouse or a significant other or adult children, then in an emergency, the medical providers can be really trying to figure out, you know, who we should have making decisions. So, for example, they're going to have to go all the way to adult aunt and uncle, and you have a, you know, neighbor or friend who you prefer to make the decisions. It can be really good to get that down, so that someone who knows you closely is able to make those decisions versus whoever the state decides in an emergency should make those. Next slide. So they're supposed to follow, medical providers are supposed to follow the principal, the principal is the person who makes the power of attorney. They're supposed to follow their written wishes. And if they can't for some reason, maybe Catholic facilities or something like that, they have to transfer someone to a facility that will. However, you know, they can't follow these documents unless they actually have them, which is a big thing. So sometimes people will do these documents and then never go back to them. You know, 5–10 years later, they might be like, well, I know I have a power of attorney, but I don't know where it is. It doesn't really help in those instances. They can't follow it if they don't have it. And particularly with healthcare documents, updating them periodically is also a good idea, because your preferences and treatment options also change. Yeah, next slide. Oh, I forgot that was on the next slide. So just briefly, you know, making sure that, you know, your primary care doctor and that you're carrying it, so that people are aware of this and that it's in your chart. Talking to your doctor about a do not resuscitate, and if you have a critical medical condition, getting that pulse chart done as well, so that those choices can be followed in an emergency particularly. Next slide. So with the healthcare documents, those are generally, I don't know exactly how it is in other states, but in Maine, healthcare documents you can get in a number of places. I think all states, you know, you can get these documents online probably without too much trouble. In Maine, we use the Maine Hospital Association form. I know other organizations like the VA have their own forms. With financial power of attorneys, it's not something, and I definitely think that this is the same in other states, just because these documents, you're naming someone who is going to be able to manage your legal and financial affairs, so the consequences of that can be really serious, and there are specific state law requirements. So in Maine, for example, I've never seen someone be able to go online and download one of these forms and actually have it be valid in Maine, because there are specific statutory notices that have to be on the forms. Other states, you might be able to download a form online and have it be legally valid, but because of the potential consequences of these documents, you're giving someone access to your finances, essentially. I don't think anyone recommends people do that, kind of just go online and download a form. So generally, we recommend you have an attorney at least discuss with you the consequences on these. Like with a healthcare power of attorney, you can name anyone that you want. Essentially, you can have it be starting immediately or only upon incapacity. I say, like with the healthcare document, if you don't trust the person to make decisions while you're competent, though, they're probably not a good choice to be able to make decisions after you're incapacitated. Some people only want it to start when they're incapacitated, which I understand. However, these documents, the principal in any power of attorney, they always have the right to overrule their agent. So if they start immediately, you still have the right to make decisions. I think that's covered in one of the next slides, but we'll get to it. So powers, and durable just means that it would last beyond your incapacity. And also powers of attorney expire when the principal dies. Everything else past that, governed by will, things like that. Next slide. So your agent will have a lot of authority generally once it is in effect. You can write these pretty narrowly. You can give as broad or as narrow an authority as you want in the document. Generally, for the financial power of attorney, you're having an actual attorney prepare it for you, so you can kind of tailor it a bit. But your agent will be able to, in general, sell your property, spend your money, cash checks, enter contracts, handle legal matters for you. So just really a lot of vital roles that your agent can play for you. One thing is Social Security doesn't accept power of attorney documents. That's something we run into. They have their own system for vetting people. So just be warned. Next slide. So there are certain limitations on your agent. They have to keep the money separate from their own. They're not supposed to profit from the transaction, so they have a fiduciary duty. They have to keep records and provide an accounting. Sometimes power of attorneys have what's called a gifting provision. This is for wealthy people who need like estate planning and who, as part of their estate planning, generally give money away or move it around. It's a dangerous provision for obvious reasons to give someone the ability to give away your money, but some have that in there. You can have other limitations in the document if you want as well, if it's written in. Next slide. So any power of attorney, the principal is always able to make decisions as long as they are able to. So you don't lose your individual rights as soon as you sign a power of attorney. You can always overrule the agent. Even when you can't make decisions on your own anymore and the agent takes over, they still have a fiduciary responsibility to you, and they have to act in the principal's best interest and as the principal would want them to. They're not supposed to substitute their decisions for the principal's. So the other big protection is that all power of attorneys you can always revoke them if you're competent. So that's a big one. We do that a lot for people when they're not happy with how their agent is acting. Next slide. So if you don't have one of these documents, what happens is that in an emergency, your bills might not get paid. A court might have to step in and appoint a guardian or a conservator. In general, a guardian is someone who has authority to make decisions over someone's person, so like healthcare decisions or where someone lives, who they can see, and a conservator is over specifically finances. So this in general constitutes a much more serious loss of independence. Someone might lose all legal ability to make decisions for themselves, and it may not be someone that the principal chooses. So it's a big deal if you end up under guardianship, and having these documents can sometimes avoid that. And even if it doesn't necessarily, if your family just wants to fight over who makes decisions about finances, generally power of attorney in it has a section where you can say who you would want as your guardian or conservator if one had to be appointed. So you at least are able to express your wishes about what you would want a court to do if it still somehow ends up in the court's hands. Next slide. So, like I said, it's some of the big differences between power of attorney and guardianship or conservatorship. Power of attorney, the principal, they're retaining their legal authority and ability to make decisions. There's not substituted judgment. So, for example, let's say someone is kind of a hoarder, and the kid who's appointed agent doesn't like that, but they know that that's how the principal wants to live. As soon as the principal becomes incapacitated, the agent has to act in their best interest. They can't suddenly or act as they would want. They can't suddenly just throw all of this stuff out because they don't like how the principal lives and has been living, and they don't think they should have that much stuff. But with a guardianship, they can substitute decisions. They can act in the best interest. There's different terms of the ward without necessarily considering as much how the person would want those decisions made. Next slide. So if you're kind of a third party looking at these things, you always ask to see the documents, and because often I think the next few slides are just a little bit about financial exploitation. So often you'll see people asserting authority that maybe they don't have, and maybe that's for good reasons. They're trying to be helpful, and sometimes it's not. But you have to be sure that you're reading the document and always err on the side of the senior's autonomy and their safety. Next slide. So just some general recommendations for these documents. Like I said, no one can follow them if they don't know they exist or they don't know where they are. So discuss them with people, provide copies, keep the original someplace safe, name an alternate. So often, you can name multiple agents, but then of course they sometimes just argue, and that might not be helpful. But if you have an alternate agent who can take over in case the first agent, such as a spouse, passes away or for some reason isn't able to act as an agent, then you don't have to do an all new document. It can just, the decision making can default to the backup agent. That can be very helpful. Complete a values history. So basically, you might name an agent and say, well, I really trust them, but if they don't know what your values are, then it can be difficult for them to make decisions as you would. So often someone close to you already knows those things, but if you discuss them, that's also a really great idea. Next slide. So tips for choosing an agent. A lot of it is, whether you trust this person, but also how well do they know you and do they respect your point of view? Are they willing to stay in touch is a big one. Are they willing to do the work? With healthcare, power of attorney, they might not have that much work to do. It might just be kind of stepping in an emergency. But with financial power of attorney, you might be naming someone so that they can, make sure all of your bills are paid, so they can communicate with insurance companies. Are they willing to actually do that? And do they have the knowledge to do it appropriately? And for both of these kind of documents, but particularly for the healthcare one, in a crisis, are they going to remain calm and make the decisions that you would want? Next slide. So just a little bit about financial exploitation, because I think I'm like about out of time. So it's very common, unfortunately, generally a family member or caregiver, and it's just the illegal or improper use of a senior's money or property. Next slide. So there's lots of different red flags, but changes in financial patterns, someone being unaware of their income or resources, sometimes that's fine. It just means they have an agent who is taking care of all their finances and doing it appropriately, but sometimes it can mean that something inappropriate is happening, particularly if there's a disparity between what you know to be their income or resources and how they're living. Unpaid bills is another red flag. Someone refusing to leave the senior to talk privately is another red flag. But all of these things can be, have other explanations. So it's kind of just some things to watch out for and ask for further information about. Next slide. So these are just some common examples. It can be forging signatures, it can be overcharging for services, it can be forcing someone to change their will or do a new power of attorney. It can be making them sign over real estate, adding themselves to a bank account, things like that. So there's a million ways to take a senior's money, unfortunately. Next slide. So preventing financial exploitation. Joint accounts can be very helpful, but can also be dangerous because the person who is joint on the account has access to the full account. And also if your bank account might end up entangled in their legal issues if they ever have one, like a divorce or a civil case against them. Amateur estate planning is particularly dangerous for Medicaid purposes. We see that sometimes is a tool of exploitation, and sometimes just they do it really badly and mess things up for a senior for their long-term care Medicaid eligibility. Beware of a power of attorney agent who really wants the job. They could just be trying to steal money. The evil handyman, proprietary relative, unvetted caregivers, all of these can be dangerous. So in just spreading awareness about how common this is and making people less embarrassed about when it happens to them so that they will report it or, we'll talk to others about what's happened and people become more aware of this is really important. So next slide. So this is our organization, Maine Legal Services for the Elderly. So if you have a senior in Maine, the only requirements to call us, they have to be a Maine resident and they have to be 60 or older. We're free to call. We provide civil legal services, and we don't, there's no income test for our services. So the next few slides, I think, I looked up. So the other, you can go back. Yeah, so there's other legal aid providers. Vermont Legal Aid Elder Law Project and the New Hampshire Legal Assistant Senior Law Project, and then for non-legal aid resources, because legal aid doesn't cover everything a senior might need. Like for example, we don't do wills, but we do referrals for them. But for personal injury cases and things like that, the state bar associations have referral services for private attorneys. And next slide. And then this is the last thing to be aware of. So state adult protective services, those are state programs that investigate allegations of abuse, neglect, or exploitation. So they can provide referrals and help arrange services, but if an adult has capacity, they can decline. And they sometimes can go further to assure safety if the senior or adult lacks capacity to make decisions, for example, in Maine, they can seek guardianship or conservatorship over incapacitated adults. But in general, their role is to investigate abuse and to help connect a senior with resources. So they're always a good resource to be aware of, but their role is limited. And that was pretty much it. I sped right through that.
You did great. I'm very, very impressed. So we do have some time for question and answers. So if there's anybody who has a question, I'd encourage you to unmute yourself and ask the question directly. If you don't have that capacity, you can always put the question in the chat box.
Hi, Hilary. This is Emily Barrell from the Elder Abuse Institute of Maine. I just had a quick question maybe about what you would recommend for people who don't have any family or friends who could be like a POA and are also low income, but could really benefit from some assistance due to capacity issues and other things.
Yeah, that's always a really hard one for people who don't have someone trustworthy who can be a power of attorney or an agent under a power of attorney. So sometimes, for example, if they have like SSI, there are organizations that provide services to act as representative payee, which is what Social Security uses instead of power of attorney to allow someone control over finances. So a Social Security representative payee receives Social Security money directly and sends it for the principal. So that can be really good for people if they are in that situation. But for people who are not, there are, like with in Maine, the agencies, local agencies on aging, they have programs like money minders where they actually help someone sit down and balance their checkbook every month and make sure bills are paid. Those can be, even if someone has some degree of impairment, a good program to use as long as they're able. They can't take on the role of agent under a power of attorney, but they can be kind of a stopgap measure while someone still has some capacity, but might need help to make sure they're not missing bills every month or something like that. There are, if someone is low income, it's hard because there are not really that many organizations or services for someone to get someone trustworthy in there to handle finances for someone. If they have more money, then they can pay, some attorneys will be agents under a power of attorney and things like that, but that's often very expensive for them to do. There are also some, I know down in southern Maine, there's a firm that also will do that for people. It's probably cheaper than having a law firm do it, but it is a gap for people because I often run into that situation where someone is low income and needs a trustworthy agent to handle finances, and I just don't have a place to refer them to. So I don't really have a great answer for that. It is something that I see a need for more options for.
Thank you. Mark has asked the question, do you have a template for discussing values with clients?
I don't really. So I think that there are some of the, like the Maine Hospital Association form that we use for our advanced directive doesn't go into it too much. There's generally a place where you can put, just general treatment choices, but our clients are generally pretty straightforward. We encourage them to talk about their values with their agents, but I know that there are other advanced directive forms that go into that more. And they kind of, I think, kind of go through specific choices. We don't do advanced directives with people that often. So I don't really have, I don't do that much.
Not to put you on the spot, but Anne Schroth, did you want to comment on how somebody might if you've got ideas, have conversations related to values.
I'm so sorry, I was distracted by a kid here, so I missed the question.
The question was, is there a template for discussing values with people? And I didn't know, based on your work around advanced directives, if you had anything in specific.
There's a lot of information in our project, which I don't run, but which Janet has tons of information, Choices That Matter, but also one of the ones that we've been using, especially in this time, is the Conversation Project. They have tons of information online, especially as it relates to COVID-19. And